Hey, everybody. Hope you are doing well. Coming to you with a couple of updates in the Bryan Kohberger case, one of them being a response of the discovery from the plaintiff, and then a big motion being filed. And it is actually concerning a public hearing in a case that Bryan Kohberger is involved in. And so I want to go through some of these headlines with you, get your perspective. Don't forget to leave a comment down in the comment section because it is so helpful for me to get your feedback on your opinions on this case. I don't necessarily care about your opinions on things that are so personal, but definitely your opinions on this case. Jennifer Koffendorfer says, "While I have not seen the plaintiff's discovery request, here is Bryan Kohberger's discovery response. If you've not seen it, she said there's interesting caveats stating that it won't be submitted at trial, not that he doesn't have them. And then she includes that at this time are the operative words. So you guys can see here, this is the state of Idaho versus Bryan Kohberger. This is Bryan Kohberger's response to the plaintiff's request for discovery. What does that mean? The plaintiffs asked Bryan Kohberger's team to turn over what it is they have. Come now, Bryan Kohberger, by and through the attorney and Taylor, public defender, hereby submits the following response to plaintiff's request for discovery. There are no books, papers, documents, photographs, or copies or portions thereof in the possession of the defendant at this time, which will be submitted at the time of trial. The defendant may use any books, papers, documents, photographs, copies, or portions thereof, which may have been disclosed by the state in discovery material. There are no results or reports of physical or mental examinations or scientific tests which are in possession of the defendant at this time, which will be submitted at the time of trial. The defendant may use the results or the reports of any physical or mental examinations or scientific tests which have been disclosed by the state in discovery materials. The defendant may also call as a witness people that were disclosed as potential witness by the state and any other persons who were named by the state within their own discovery materials. When available, the defendant will provide the names and addresses of any additional witnesses who will be called at trial on behalf of the defendant. And so you guys could see at this time, there's nothing in our possession, no books, papers, documents, nothing at this time. There's no results, physical exams, scientific tests at this time. Which means, according to Jennifer Koffendorfer, if you guys can see in her tweet, it's not that he doesn't have them, they're just not submitting them at this time. So Mercy says the defense only has to turn over if they plan on using it at trial. Jennifer says correct, but it often changes. Always something to see, and you can't know what to look for. Pointless says the importance is the apparent lack of an alibi. Jennifer Koffenhoff says there is no alibi if you believe the probable cause affidavit. Archer says interesting that you don't characterize this prosecution pressing or point out that the defense knows what they have to provide. Jennifer says, well, this was in response to the prosecution's request, which happened at the beginning of the case. The initial requests were, of course, expected. She says, I'm only making comments you referred to in response to the recent defense requests, which are duplicitous but expected. Dell says the defendant has a right to remain silent. Jennifer says, well, they must produce to the prosecution evidence they plan to produce at trial. Shannon says, this is a form answer to discovery. Jennifer's like, yes, as are the prosecution's response. I hadn't seen anyone post the defense responses. And for those who don't see this paperwork all the time, it's important to note that there might be introducing documents later. I'm going to take that to mean they're going to be introducing documents later. Here's the other piece of information that I thought was interesting. She says, wow, a public hearing concerning the Gonsalves motion regarded the non-disclosure order. Well. One of the things that I'm thinking of is maybe this would actually be something that is foreshadowing what's to come in the future. This is the notice of a remote hearing. This is plaintiff versus Bryan Kohberger. It's taking place now on May 22nd. That was going to be taking place on May 25th. It's moved up to the 22nd, which is literally just 2 weeks away. It's on a Monday. And there is Zoom. They have the meeting ID and a password. It says you must appear using video with stable internet connection. If you're unable to do so, or if you require accommodations, contact the Latell County's clerk office for a list of best practices. Go to this website. It is the policy of the Idaho Supreme Court that the court proceedings are presumed to be open to the public in the absence of a court rule. I think that this is fantastic. Open to the public. This is the clerk of the court, Julie Fry, and it's signed by Jennifer Oliphant, who's the deputy clerk, just making the motion that this is going to be a public hearing. This is likely foreshadowing, guys, of what's to take place in this case. Scheduling conference, Judge Megan Marshall on Zoom. And then you guys can see here online videos and online hearings are real hearings. Behave as you would in a courthouse. Find a quiet place, check your video, don't walk around, silence devices, mute your microphones, do not interrupt, use the screen name. Some of you guys would remember other cases that we were following in this sort of true crime world that we're in. And the folks that were watching the video that were YouTubers streaming to their YouTube video were literally talking out loud and it ruined the trial. And so that's partially the fault of people who are running the trial. They shouldn't allow true crime YouTubers in the Zoom session with their microphones to be unmuted. And then it is partially the fault of true crime YouTubers who don't need to be doing that stuff. Here's the rundown. On May 2nd, the Associated Press filed a motion to intervene and a motion to vacate the amended non dissemination order. The Gonsalves' motion and the Associated Press et al.'s motion concern the same subject matter, the amended non dissemination order, and it should be set for a hearing at the same time for judicial efficiency, therefore, after due consideration. It is hereby ordered that the motion hearing, Gonsalves' motion to appeal, is vacated. It's interesting. It's going to Judge Megan Marshall, by the way, who's the one who created the non-dissemination order. She creates a non-dissemination order, signs it, and then they're basically saying, "Oh, we appeal what you just came up with," as if she's going to overturn it. It's just going to wind up right back at the Idaho Supreme Court. That's not really the main point that I'm thinking of in this moment. It is that there's a scheduling conference that is public via Zoom. It is further ordered that any recording or live streaming is prohibited, which means YouTubers definitely uh, better not be on there. They can't record it, they can't live stream it, but they can definitely live tweet it. They can certainly share their perspectives of what's going on via the tweet world. And I think the reason why this is so important is because it's possibly foreshadowing to what we're going to see in that preliminary hearing that's going to be taking place just 1 month away from now in June and maybe even downline in the trial. I would just advise everybody that's interested in this case, that's been following along, be on your best behavior because we really want this to be a case that is public so we can follow along. And the most unfortunate thing that I think would take place if people like you or me or anybody abuses the responsibility that they're giving us to be honorable citizens by getting a peek into the court process. So don't go recording, don't go posting, don't go abusing, don't go on and unmute your mic. And hopefully, by the time that preliminary hearing and trial comes around, they'll still allow it to be public. Hey, thank you guys so much for taking a couple of minutes to watch today. I do want to let you know that this channel is totally crowd-funded, which means we can't do what we do unless people like you come alongside and support us. I want to invite you today to support us through PayPal, which is Tyler Feller. Cash App may be the best way because there's no fees. $sign Tyler Feller 22 or Venmo, which is at Tyler-Feller. Thank you so much.